Yes, sir.
Yeah. The next question is variations of conditions of pardon. Huh? Variations of condition of pardon. Please, the answer is Section 8 of the Probation of Offenders Act. Section 8 clearly says that here, on the application of the probation officer, the court which passes an order under Section 4 in respect of an offender is of the opinion that in the interest of the offender and the public is expedient or necessary to vary the condition of any bond entered into by the offender. It may at any time during the period when the bond is ineffective vary the bond by extending or diminishing the duration thereof. However, it shall not exceed 3 years from the date of the original order and altering the conditions thereon, provided that the variation shall be made without giving, shall not be made without giving the offender a notice in that regard. Then subclause 2 speaks of when the court, when the bond can be altered, offender refuses to comply, the court can cancel it and found him guilty. And ultimately, in cases of third one, the court can cancel the bond if it finds that here unnecessary to have the character of the accused is clean. It's like variation under Section 127 CRPC of the order of bond. So if the conduct of the accused person is very fine, he will be enlarged immediately, he will be set free. Whereas if he is not following the conditions of the bond properly, probation officer records adverse comments here, the court will either give adverse comments against him or ask him to give more sureties, otherwise he will be taken into custody. Please note that. That is a variation. Next, persons entitled to maintenance under Section 125 CRPC. 125 के अंदर number 1, the following person who are unable to maintain themselves. The condition is they should be unable to maintain themselves. Number 1, wife, legitimate or illegitimate minor child, whether married or not. Please note that. Number 3, legitimate or illegitimate child not being a married daughter who has attained majority. Child who is unable to maintain herself, then herself being on account of physical, mental abnormality or injury. Then lastly, father or mother unable to maintain themselves. So the maximum compensation which can be awarded maintenance in Maharashtra is about 1,500. Okay. Every state has a different rule. Kindly note that these are Section 125 and there are 3 or 4 groups of people are mentioned here. Then write short notes on any special powers of the High Court and session courts of bail. That is Section 439 CRPC. Section 439 are the special powers, but normally the bail is given under Section 436 in cases of bailable offense by the police officer as well as by the court. Under 437 cases of non-bailable offenses where the court grants it, normally a magistrate's court under 437. 437 and 438, anticipatory bail, and 439, the sessions court and high court, they have got special power. They can modify the terms and conditions of the magistrate granting bail earlier, or they may add further terms and conditions, or where the magistrate has failed to grant bail and the magistrate can grant bail. So you should know that here. For example, where the magistrate has no power to grant, no jurisdiction to grant bail in respect of offenses where the offense is triable by the court of session. Like in Goswami's case, that here he moved the session, first the magistrate's court in Alibag for a bail under Section 309. 309, attempt to commit suicide of that Naik. The magistrate rightly granted because the offense is triable by the sessions court. So he did not file the application in sessions court for reason best known to him. He moved the Bombay High Court under Article 226 and a writ of habeas corpus, which was rejected. Then he moved the High Court, Supreme Court under 136. He was lucky to get the order, isn't it? But ultimately, the best provision in such cases where the offense triable by the court of session is better to move the court of sessions under 439. Please note that. When the sessions court rejected, then come to the High Court. So hierarchy has to be followed. You cannot just bypass the order here. Up to under 439, these are the powers that you please kindly go to that here. The Court of Sessions and High Court may grant, they may even direct that here, if the conditions of the bail are violated by the accused person, they may ask him to be rearrested and commit him to custody under 439. Okay. Then next question. Anybody has any question on this? 439 ke upar? Remember the section 436, power of the court and police to grant bail in bailable offences. 437, power of the magistrates. Magistrate to grant bail in case non-bailable offences. Please note that. And 438, anticipatory bail, where the sessions court as well as the high court have concurrent power, whereas the magistrate has no jurisdiction to grant anticipatory bail. Please note that. Anticipatory bail is granted only in cognizable offences. You cannot go in non-cognizable cases. Non-cognizable cases, the police officer has a right to grant you bail or even right to release you on bond in the police station itself. That is why anticipatory bail not granted. You must remember that. So don't even go to a magistrate for anticipatory bail. Please go to only a court of sessions. If the court of session is not functioning for A reason, B reason, or rejected your application, then you come to the High Court under 438 for anticipatory bail. Then 439, as I told you, this is a case of an arrested person in cognizable offences can move the Sessions Court or High Court. Preferably, you must move the Session Court first. When the Session Court reject the application, then move the High Court by way of a second application, and there is no bar. There is no res judicata here, and there is no double jeopardy here. Please note that. These are all interlocutory application. One rejected, second application maintainable on the same fact. Second, third, fourth time you cannot go unless the change of circumstances take place. Okay. Then the next question is a limitation for taking cognizance of offences. Now here, you need not resort to Limitation Act of 1963. Now CRPC has got an inbuilt provision, section 468. Please see section 468, which says that bar to taking cognizance after lapse of the period of limitation. Now, section 438 में कहता है कि the limitation shall be in case 6 months if the offence is punishable with fine. If it is only an offence which is punishable with fine, then you have to file the complaint within 6 months. Okay? Then it does not apply to economic offences. Economic offences क्या होते हैं? Dowry Prohibition Act, Sati Prohibition Act. The government has listed as many as about 17 acts. What are the offences under the Economic Policy Act? That you go through that, we will come to that. Then complaint should be filed within 1 year if the offence is punishable with imprisonment for a term not exceeding 1 year. When you see the schedule, first schedule of the CRPC, उसके अंदर आपको मिलेगा first schedule के अंदर what offences are punishable for what period. See the schedule. आप schedule check करेंगे ना आपको मिलेगा. Where the offence is punishable, complaint should be filed within 1 year if the punishment is not exceeding 1 year. And complaint should be filed within 3 years if the offence is punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years. So after 3 years, if you file it here, it will be time barred. Then this is the scenario. Then it is not that here. Section 471 speaks of continuing offences like the provisions of section 22 of the Limitation Act. Then section 469 deals with commencement of the limitation period. That it commences from the time when the offence is committed or from the time when the knowledge came. As per your knowledge or knowledge of the police officer. This is your answer. If the answer is big, otherwise, if you make it short, just write it here. It is a 6-month complaint should be filed within a period of 6 months. If it is only fine, 1 year. If it is a punishment, is 1 year, and 3 years if the offence is punishable not for more than 3 years. So section 471 deals with the continuing offences, and delay can be condoned also under section 471. Yeah. Next question is uh, a person once convicted or acquitted to be tried. क्या question ही क्या? Yeah. Not to be tried for the same offense. This is a doctrine of double jeopardy. You will find it under section 300 CRPC. 300 CRPC is very interesting here. Here, a person convicted, I mean, full-fledged trial must take place. A full-fledged trial must take place, which results in conviction or acquittal. But if it is a discharge or dismiss, section 300 cannot be invoked. It is clearly mentioned. Then here, let's see that here, the illustrations are very important here. But if there are distinct offenses, for example, if A was convicted for the offense of cheating earlier, can he be tried for misappropriation? The answer is no. Then another examples are given, illustration आप check करेंगे, section 300 में is very important. Just open section 300 if you can see. Yeah, 300 ka ingredients are that here. Conviction and acquittal, there's a bar, but under the provisions of subclause 3, see the person convicted for an offense constituted and thereafter consequences flowing elsewhere, a complaint can be filed with the permission of the government and state government here. Now, and the subclause 5 says, now you know section 258 is under section 258, it's a summary trial. When evidence is deficient, the magistrate can stop the proceeding. Or when the complainant is not coming forward. Under section 258, power of the proceeding to certain cases. These are summons cases. It is in summons cases, when the proceedings are stopped, it tantamounts to discharge. Because a full-fledged trial has not taken place. Now, if such an order is passed under section 258, it is not double jeopardy. It is not res judicata. It is not double jeopardy. But with the permission of the magistrate, the case can be again restarted. Now, subsection 2 says that in the case of acquittal, where the joint offense, distinct offenses take place, under section 220 CRPC, you know that distinct offenses, charges can be multiplied. For example, cheating, misappropriation, robbery, theft, सब साथ में club हो जाएंगे. So if person is acquitted in one, suppose for example, he has been acquitted in a theft, robbery charge can be pressed again with the permission of the central state government, subsection 2. It's a distinct offense, though it may be more or less look similar one, but with the permission of the government, it can be filed. Similarly, when a private complaint, that is summons case, has been disposed of by the magistrate for want of evidence or a complainant not coming forward, a dismissal can take place. That is called stopping of the proceedings. When stopping order is passed, it amounts to discharge. But discharge itself is not, see that explanation clearly says that the dismissal of a complaint or a discharge of the accused is not an acquittal for the purpose of this section. That means can be retried. Then there are 3 illustrations. You may go through that here. Illustration A is tried for the charge of a theft and servant acquitted. He cannot afterwards be acquitted. He cannot be, while acquittal, cannot be charged with theft upon the same fact simply with criminal breach of trust. This is the case where more or less same related here cannot be charged. Now, in the case of illustration B, where he is causing grievous hurt and convicted, a person dies later on, he can be tried for culpable homicide. Because earlier was he gave blows by lathis. Evidence was deficient. He was discharged or maybe convicted. Whatever may be. Convicted ho gaya. Lekin a person thereafter dies after 6 months. So a second charge can be brought against him for under 300 IPC. That is not bar. Then C says, A is charged before the court of sessions and convicted for culpable homicide. Or B, A may not afterwards be tried for the same offense. So they are more or less murder, they cannot be repeated. Then D says, A is charged by magistrate of the first class with conviction, voluntarily causing hurt to be, then A may not afterwards voluntarily causing grievous hurt, the same act, come forward within subsection 3. So subsection 3 says that here the charge cannot be filed, provided it ensues consequences, second charge is maintainable. Then fourth is A and B and C charged by the magistrate of the offense class with the conviction by him of robbing, but they may afterward be charged for dacoity. So dacoity is a distinct and different charge, he can be clubbed. But whereas a lesser punishment is concerned, he may not be charged. So this is very important, please remember this. Then you will also find provision like this under the Constitution of India, Article 20 subclause 3 के अंदर भी है double jeopardy का. I mean that you not required because you have to answer in small question. Then what is the next question? First information report. इसके बारे में तो हम काफी पढ़ चुके हैं. Section 154 of the CRPC, isn't it? You must have been explained here. First information report is normally lodged to a police officer who should record in the writing and of the person. Conditions, there are certain amendments here. If you open up, I'll just briefly go into that. Section 154, देख लेंगे तो आप. Yeah. Yeah. 154 1A. A police officer, it is lodged in respect of offenses which are cognizable offenses, then he has to proceed. It can be lodged for both cognizable, non-cognizable, isn't it? Then offenses relating to rape and all is a proviso given here, where the statement of the woman should be recorded at her place. Police station cannot call her to station. That is very important. Then videography to be done. Please note that it's mandatory to do subclause 2 के अंदर. In such cases of the statement of the victim, the videography is mandatory now. Then there must be a judicial magistrate present in the matter. Statement of the person should be recorded by judicial magistrate. Kindly note that. These are all amendments which have been made in the year 2013. Kindly note that. Then confirmation copy should be furnished. Then when the police officer does not take cognizance under 154(1), then the agreed person need not go to the High Court or a magistrate directly. He has to go to the superior officer under 154(3). Please note that. When the sub-inspector or a senior inspector of a police station, SHO, does not take cognizance of your complaint under 154(1), then your next remedy is 154(3) to go to the superior officer after 15 days. Please note that. It is only when he doesn't take action, then your remedy will be to go before a magistrate under section 190. Please note that. Under section 190 CRPC. That is the third remedy. You need not rush to High Court now. Supreme Court said that the writ of mandamus should not be issued for the purpose of directing a registration. The remedy is 190, cognizance of offense by magistrate. Now, if you want to understand what is 154, 154(1), 154(3), and 190, please read judgment of the Supreme Court in Priyanka Srivastava versus State of UP. Please, Mansi, open Priyanka Srivastava versus State of UP. 2016 Supreme Court cases. Judgment of Justice Deepak Mishra. It's a landmark judgment. Yeah, Priyanka Srivastava versus State of UP. Please remember this. This is a very important judgment which says that here, when you file a FIR, when FIR is not taken cognizance of, don't go to magistrate directly. Go before a senior officer under 154(3). Only when he refuses to take action, go under 190 to the magistrate. Under 190, magistrate has power to take suo motu cognizance or either direct investigation under 156(3) also, under this provision. Suppose the police officer is not registering a FIR for A reason, B reason. You have a right to point out to him the judgment of the Constitution when the Supreme Court in Lalita Kumari versus State of UP. Mansi, please open Lalita Kumari versus State of UP. (2014) SCC का है, page number 1. 2014 2 SCC, page number 1. Lalita Kumari versus State of UP. So it is mandate, it's a constitution when judgment the police officer must follow. Yes, if this is violated by the police officer, you can take resort to this and go before the High Court or even before a magistrate. You can tell him, why is he not registering my FIR? Registration of FIR is mandatory. Yes, arrest is not compulsory. For arrest ke liye section 41 has to be seen. In certain cases, notice to be issued. In domestic violence matter, you cannot immediately arrest. You must hold inquiries. Preliminary inquiry to be held by the police officer. So these guidelines, you please remember. Lalita Kumari's judgment, State of UP, if for one non-registration of FIR, this must be a case. And for not filing, for not taking a FIR, and the police or senior officer not recording, and you want to file a complaint in respect of a cognizable offense, you can go to the magistrate under section 190, pointing out to the magistrate that you had filed a FIR under section 154(1). The police officer did not take cognizance. Then I went to the senior officer, namely Assistant Commissioner of Police, invoking his power under section 154 subclause 3 CRPC, but he also failed. I am compelled to come before your lordship. Then along with this, you have to file an affidavit now. Now Priyanka Srivastava says the complainant must file affidavit placing on record this fact, the cognizance was not taken. Please note that this is all when a trial takes place. You know the trial, there's a session trial, a trial of a warrant case before a magistrate, and a trial of a case before a magistrate, otherwise than a police report. So your complaint will be under section 190, will be in respect of a trial, which will be under the provisions of chapter 8 of the CRPC. When you open section 225 onwards, the trial starts. The trial before a magistrate in warrant cases starts from section 238. See, trial of warrant cases by magistrate. So this is a trial pursuant to a report under section 173. Okay, 173. Now, another trial is a commencing is a that is a section 244 Cr.P.C. cases instituted otherwise done on a police report. So this is also a warrant trial. This is where section 190 complaint is made. Section 244. These are all warrant cases otherwise than a police report. This is a private complaint which is filed by you under section 200 CRPC. Please open section 200, Mansi, where the procedure is followed by the magistrate. See, examination of the complainant होगा उसके अंदर. This take place after 190. the court will record evidence. The court may send the matter for investigation or inquiry or postpone the process, or under section issue the process under the 202 or dismiss the complaint under 203. So at this stage, accused is not called. It is not like a civil case where the notice is given to the defendant. So the magistrate, only when the magistrate take cognizance, when he admits the complaint, when issuing process, then issuing process coming under section 204. When a process is issued, then thereafter the accused appears for the first time. Till then, the accused has no right to say, I had not been heard, principles of natural justice are violated, principles of audi alteram violated. No, there is no necessity for this. Judicial magistrate exercises judicial mind. He will take care whether in such matters the personal liberty of the accused is violated or not. Complainant has a sufficient case, prima facie case is made or not. Whether the complainant has gone to the police first or not, whether he went to the senior officer or not, whether he has filed affidavit or not, whether he has shown the list of witnesses or not, whether he has a triable case, whether prima facie case, then only he will issue process in the matter. Otherwise, he may say that I am directing police to investigate. Kindly see that the police need not take cognizance. Under section 202, he will send the matter for police investigation. Or he may say that I am sending it for inquiry by another magistrate. So it's a lengthy procedure. Or he may say that I have examined the witnesses. So under section 201, he will examine the witnesses. The question of cross-examination doesn't come here at this stage because the accused is not present. In Salman Khan's case, why he got acquitted? Why? Because under section 200, the police officer who lodged a complaint against him was examined and filed a complaint under 200. The magistrate took cognizance. Before the court of session, the session court took up the plea that here the accused was not given right of cross-examination. The question of cross-examination doesn't come here under 200 because notice is not issued to the accused person. That only comes and only after 204 exercise is done. So with due respect, the judgment of the trial court was not correct. I mean, the session court was not correct, and rightly the Bombay High Court passed the order discharging him in the matter because there is no question of cross-examination of the accused person under 200. So that's the procedure here. Yes. So please remember this. Next question will be dealing. Next question is
Question, sir.
Yeah.
Sir, under in the Salman, sir, in the Salman Khan case, should it have been tried as an accident, or were they right to impose the charge, homicide not amounting to murder?
At the time when the offense was committed, it was an accidental case, isn't it?
Yes, sir.
It was an accidental case. Thereafter, the act was amended, to make it more consequences serious. But before the act, it was a lesser offense. So when the magistrate took cognizance of the matter, he is not bound to hear the accused person. He rightly issued process against him. And the evidence of the police officer under 200 cannot be used at any stage. Please note that. That man died and gone, whatever may be, dying declaration may be, that evidence cannot be used for convicting a man. Because under the Evidence Act, if you want to convict a man, use his evidence, he must have been cross-examined. That you will find the provision under section 33 of the Indian Evidence Act. That will deal with later on when we come. Of course, Evidence Act should have been clubbed along with the Cr.P.C and C.P.C, but unfortunately it is not. They are separated. Okay?
Yes, sir. Thank you.
Yeah. The next question here is here. Anticipatory bail. This we have discussed it here. Section 438 ke andar, only the Court of Sessions and the High Court has power to grant the anticipatory bail. Anticipatory bail is available to a person who has been accused of in the cognizable offenses, non-bailable offenses. Please note that here. Non-bailable offenses, check karo aap. That's the condition precedent. Only the Court of Sessions and the High Court can grant the condition. They may impose conditions in the matter. Normally, the court sees that here that the accused is a respectable person. He has firm roots in society. He will not tamper with evidence, and the prima facie the offence is not made out against him, or maybe malicious with a view to so and so. So these are the court may grant condition. Say, I am letting you out on a condition: deposit your passport. Don't travel out of India without the permission of the court. And you should not tamper with witnesses. You should not be going in that particular area. So these are the terms and conditions which are imposed. And the court is normally liberal in granting anticipatory bail, but it's a discretionary order depending upon each judge of the court, Sessions Court and High Court, and accused cannot, as a matter of right, claim it. Okay? Anybody has any question? Next question is appeal from conviction.
So 7 minutes are left.
7 minutes. I will cover this. I think only this question. Appeal from conviction 374 mein hoga ji. Answer is so an appeal from the conviction of the High Court order go to Supreme Court, then convicted by a person. I did session conviction from the magistrate Sessions Court mein jayenge, session ka High Court mein aayenge aap. Please go through this. Any magistrate court here. Then yes. Then a situational problem check kar lenge aap. Any two. A is tried for causing grievous hurt and convicted. The person injured dies afterward. Can he be tried for culpable homicide? Give reason. Yes. See illustration B to section 300, please. Abhi check kare. Mansi, please read illustration B. This is very important. Students should read. This is picked up from section 300 illustration. Illustration B. Okay, got it?
Yes, sir.
This is the answer. So don't write the answer that here he cannot be tried. He can be tried because it is a subsequent act here, which is a different charge. Please go through the illustration and Cr.P.C. very carefully. That is your problem. Now the next is A is accused of theft of certain. No, I'm sorry. The question. A is accused of theft of certain articles at certain time and place. While framing a charge, would it be necessary to set out manner in which theft is committed? What is the answer? Not required. Not required. See section 213, illustration A. Mansi, please take out illustration A. No, section 213 said that. मिला आपको 213?
Yes, sir.
Yeah. Section 213 is the answer. Illustration. Section. Let us go through the section quickly here. When the manner of committing offense must be stated. When the nature of the offense is such that the particulars mentioned in 211, 212 do not give the accused sufficient notice of the matter with which he is charged, the charge shall contain such particulars of the manner in which the alleged offense was committed, a sufficient purpose. Now, please, your answer is illustration A. Now, check here. A is accused of the theft of certain article at certain time and place. The charge need not set out the manner in which effort. चोरी के लिए चोर को बोलने की जरूरत नहीं. You have done चोरी in a particular manner. बैठ के किए, सो के किए, जागते हुए किए, while having drunk and done it, that is immaterial. Okay. But whereas in the case of cheating, you have to give it. Now, next question. Then next question is next question is तुम्हारा question is in another case, A is accused of cheating B at a given time and place. While framing a charge, would it be necessary to set out the manner in which A cheated? Yes. Illustration B check करो उसके लिए. Section 21B का illustration B. A is accused of cheating B. The accused may set out the manner in which he is cheated. So, in the case of A example, that is in the case of charge relating to theft, particulars of theft need not be given. Whereas in a case of cheating, cheating was done deceptively. Cheating was done रात में lurking house, lurkingly, whether knowing घर से उठाया गया, बैंक से उठाया गया पैसा. Those particulars are required to be furnished, whereas in the other cases, not given. Understood this case? Yeah. Yeah. और कुछ है question इसका? Yeah. Next question. और question है क्या? Yeah. Ex-son and daughter are seeking maintenance of X from X. The son is major. The son is major, whereas daughter is minor and married. Advise them. So here major son cannot get it. Section 125B nikalo of the CRPC. 125B CRP only daughter can claim provided she is unable to maintain herself, irrespective of she is minor or minor. Okay. But as son, major son cannot claim it. Answer is section 125B.
So 2.5 minutes are left.
Bataiye, anybody has any question now?
So in this A, in part A, you said that so under section 300 of CRPC, how can he be tried for the same offense twice? He's just beaten up that person.
Haji? He has
In
beaten up
part
that
A,
person.
yeah, and he was convicted. So how can he be charged again?
Consequences have flown na. Section 300 ka dekho aap consequences. Please see sections 300 clause 2. Section 300 में आप clause 2 check him afterwards tried for consent. Yeah, see subclause 3. A person convicted in an offense constituted by any act causing consequences which together with act constituted a different offense from that of which he was convicted may afterward be tried. May be tried for such last mentioned offense if the consequences had not happened or were not known. So the consequences of death were known to you later on only. No? And it's a distinct offense. So your matter will be coming under section 300 and subclause 3. Got it?
Got it, sir. Thank you. So the first charge will be dropped, sir. The
First
charge
chop
will
is
be
on because first chop, he has been convicted there. He has been convicted. That stands. So he
that
can,
stands. Okay.
you can, that stand. Why should it be dropped? But for the purpose of counting is a jail term, that will be counted because he will not be twice kept punishment. Mein. If it's a life imprisonment, may include ho jayega.
Okay, sir. Thank
so
you.
I think today the time is up. I think, no, isn't it?
Yeah, yes, almost up.
Yes. Okay, no problem. One question is solve करेंगे हम लोग. I think if we solve 3 questions more or less on the same line, अभी कल छुट्टी दे दो मुझे को, परसों मिलेंगे हम लोग, day after tomorrow. Okay? If anybody has any more question, please ask me. And see, now we are not only, yes.
So I'll end the meeting.
Yes, beta.
Thank you, sir.
पूछो. Anybody has any question? Anybody
No,
wants
sir.
to ask any question? कुछ है question?